Hello and welcome to episode 55 of Not Reserving Judgment, a podcast about the latest intrigues, triumphs, and outrages in Canadian constitutional law. I'm Josh Dehaas, counsel with the Canadian Constitution Foundation.
I'm Joanna Baron, Executive Director of the CCF. Welcome back, Josh, from your epic trip to Japan.
Thank you.
Our colleague Christine is away today. In today's episode, I'm going to talk about British Columbia's plan to expand involuntary treatment for people facing drug addiction and mental illness.
And we'll share our bad legal takes of the week, where we take a lighthearted look at some legal opinions that didn't quite land. But first, I'm going to talk about something that I find deeply troubling, which is the British Columbia Law Society's attack on two of its members for simply requesting that the content of a mandatory Indigenous training course not contain factual inaccuracies. And you might have read about this story already in a column by National Post's Jamie Sarkonak, but it's only gotten worse since she brought it to light. Essentially, what's happening is that lawyers in British Columbia are required to take a course to increase their Indigenous cultural competence. And the course contains what is now widely understood to be a factual error on a really important subject. And when two men tried to get this corrected, rather than doing what any institution that cares about the truth ought to do and just fix the mistake, the BC Law Society, that is the body that decides who is allowed to be a lawyer in British Columbia, put out a statement smearing these two men and suggesting that they're racist. So here's the backstory. As listeners of this podcast are well aware, back in May 2021, Kamloops First Nations chief reported that an unmarked burial site containing the bodies of 215 children of the former Kamloops Indian Residential School had been discovered using ground-penetrating radar. And this quickly led to erroneous headlines by irresponsible journalists, including most famously the New York Times, that there had been a mass grave located at Kamloops, and suggestions that other mass graves existed at residential schools across Canada, and that this was evidence of mass genocide. And it led to a spasm of sort of vitriol against Canadian institutions, tearing down statues. Dozens of Catholic churches burned to the ground during this period, and the speculation is that this is closely related. The flags were at half-mast across the country. Not to mention there was a lot of pain for Indigenous people who had to grapple with the idea that residential schools had been even more horrifying and awful than had previously been known. But it soon became apparent that, in fact, no mass grave had been confirmed or found at Kamloops, and no bodies had been found. And frankly, the idea that hundreds of bodies are buried in that orchard beside the old residential school doesn't line up with a lot of the historical records. And since then, Ottawa has handed out tens of millions, if not hundreds of millions at this point, to search for these bodies. And frankly, none have been found. And even the Kamloops First Nation is now careful to state that what was discovered were anomalies rather than bodies. And it's frankly rumored now that this might have been drainage tiles that were located, and that's a rumor, obviously. And we don't really know the truth, and we probably won't, because even though taxpayers have spent millions to get to the truth, this Kamloops First Nation has decided not to share their findings publicly. Now, of course, the lack of bodies at Kamloops shouldn't detract from the fact that residential schools were immoral and they shouldn't have happened, and children were taken away from their parents, their communities. They were forced not to speak their native languages so that their cultures would be erased, and many kids faced psychological, physical, sexual abuse, the type of stuff that runs rampant in these sorts of big institutions. And some children did die, in many cases tragically, from diseases like tuberculosis that spread in institutions, and they were buried away from their parents. But all that doesn't detract from the fact that no bodies have been uncovered, and there's nothing racist about trying to correct the record on that. Yet, apparently, someone at the BC Law Society doesn't agree with that. And I say this because lawyer James Heller wrote to the course providers asking them to correct the false claim that, quote, bodies of 215 children had been discovered, and just simply say instead there was the discovery of a potential unmarked burial site. At first, he received no response. So instead of dropping this, he decided, along with a second lawyer named Mark T.K, to ask lawyers across the province in BC to vote on a resolution at their annual general meeting that would force the course material to be corrected. And they said this error needed to be corrected because, quote, adherence to facts and evidence is a cornerstone of the practice of law, and they cited the evidence as it now stands. And this should have shamed the Law Society into putting out a statement agreeing they would immediately amend the course, but instead, and this is the shocking part, the Law Society put out this statement implying that these two men are racist for asking that the correction be made. And the statement reads in part, the resolution submitted by Mr. Heller and Mr. Barry only highlights the need for the course and confirms much work remains to be done to increase knowledge and understanding, continue our efforts to advance meaningful reconciliation with Indigenous people, and eliminate racism in our profession. The views expressed in the resolution do not reflect those of the Law Society. To be clear, the views expressed in the resolution are quite simply that a mandatory course on an extremely sensitive topic ought not contain a falsehood because lawyers are supposed to care about the truth. And this is absolutely chilling to see because lawyers have a duty to act honorably and ethically and stand up for the truth, which is all these men are trying to do, and yet they're being publicly shamed for it by their own law society. So what happens next? Well, the vote is on Tuesday, September 24th, on whether or not this falsehood should be corrected. And I'm not optimistic that it will, because time and time again, when lawyers have been forced to vote on these types of things, they often just simply go along with the woke point of view rather than thinking critically about what's going on. And personally, I'm pretty worried that the legal profession is increasingly beholden to these kinds of irrational ideologies, because even though historically lawyers have been the ones out there defending the truth, that doesn't seem to be the case anymore. And I've been thinking about why that is. I think a lot of it is that law schools are the gatekeepers for who becomes a lawyer in Canada. And a lot of them are increasingly dominated by sort of radical Marxist types who don't really care much about the truth. And, they're the ones who decide who gets into law school. So I think they're weeding out people that are sort of a threat to their ideology. So I think we have a big problem, and I don't know how to solve it, Joanna, but I do think a good start would be for people in BC to vote next week in favor of the truth. And that's all I wanted to say about that. Joanna, you've read about this story. What's your reaction?
Yeah, I mean, the real thing that strikes me is this is an issue of, what happens to a society when you prioritize identity politics. Essentially, this is wokeism is a form of identity politics over the truth. And sorry to go all Peterson on you, but this is a quote from Solzhenitsyn. Truth must be told and things must change. If words are not about real things and do not cause things to happen, what is the good of them? So once you untether our language and our rules and our whole legal profession from truth, first of all, in my mind, it completely discredits the existing horror of the truth, right? Which is the existing horror of residential schools and what happened and the knock-on effects of how they've affected Indigenous communities. Importing these things that, literally making people recite 2 + 2 = 5 detracts from the real horrors. And then in terms of your point about why this is happening and why, lawyers seem to be just agents of an ideological agenda as reflected in the law schools and the professional institutions, I think this is a bigger cultural phenomenon, right? Like we're all swimming in the same water. And this is something that exists on the left and the right, where you're seeing an increasing propensity to just privilege ideology, clicks, I don't know, dopamine hits, like this whole thing with this historian, Daryl Cooper, who went on Tucker Carlson, which is the most popular podcast in the world, to say that Churchill was the true villain of World War II, and what happened with the Jews was just a mistake that the Nazis ended up having to deal with. But yes, once you untether language and the sort of discourses that we're all swimming in, we get into very scary territory. And so I just want to be clear that this is by no means just a problem on the left, although in the Canadian legal profession is primarily a problem on the left. So very bad, and we'll be watching this closely. All right, should we take a break and then we'll come back? And unfortunately, I don't have a more cheerful topic to talk about.
Sure.
Okay, so I'm going to talk about some news. This BC election run-up, which is going to be held next month, has brought up a lot of different interesting policy pivots and flip-flops, things like the carbon tax. But I want to talk about an announcement from the BC Premier, who's an NDP politician, David Eby, who announced this week that the untenable, escalating, toxic drug crisis in British Columbia warrants forcing those who are severely addicted and floridly mentally ill into involuntary care. The tipping point for this appears to have been a very tragic incident where a 13-year-old girl who was living in an encampment on the downtown east side overdosed. And this was after her family had tried unsuccessfully to get her into care when she refused. And so, first of all, it's important to emphasize, I think the media has been skating over this, that BC already allows involuntary treatment. It's the only jurisdiction in Canada where patients with involuntary status, including people detained in psychiatric facilities, can be deemed to consent to all forms of treatment. So under the BC Medical Health Act, or the MHA, a patient can be forcibly administered psychotropic medications, things like electroconvulsive therapy, or just held in custody without consent from either the patient or their legal guardians. So BC already allows this, but Eby is basically endorsing it and also going to expand how it's provided. So he said he's going to create 400 involuntary care beds in prisons and hospitals, starting with a secure facility in Maple Ridge. It seems to me that 400 is going to be really just a drop in the can. But he said that all of these facilities will provide involuntary care under the BC Mental Health Act. Now, the other contender who looks to be in the game, especially after the dropout of BC United leader Kevin Falcom, John Ruston of the Conservative Party, already has a platform that is making what he calls compassionate involuntary care a key tool in dealing with the medical emergency in BC. And the Conservatives would also change legislation to allow parents to force their children into treatment. This has been critiqued predictably by the BC Green Party leader, Sonia Furstenau. She said that he was embracing right-wing reactionary politics. She critiqued the evidence of the efficacy of involuntary care. She said there's little evidence that it reduces rehospitalization or repeat offenses. And Furstenau has a point here. We talked about this back in April when New Brunswick put forward its own Compassionate Care Act to expand involuntary treatment or bring in involuntary treatment. And Josh, you gave a very helpful summary. I know because I listened back to this yesterday morning before I did a media interview about this, going over Professor Carrie Frock, who's a New Brunswick law professor, her submission on this, which goes over an aggregate amount of studies from 2017 that shows that there's no effect on recidivism, no effect on recommitting violent offenses once these individuals are released, because in general, eventually they have to be released, particularly no good evidence on what happens to youths and children who are involuntarily committed. But it's also very hard to square that with this clear, tragic example of a 13-year-old girl where, yes, it's clear that if she had been involuntarily committed, she probably would be alive. So that's all I can really say about that. So Indigenous communities in BC are all on board for this. Musqueam Chief Sparrow said he's 100% in support of the moves. Indigenous individuals are, of course, vastly overrepresented in both prisons and psychiatric facilities. They are 6% of the population, but 35% of those who are incarcerated. And so the guidelines for how a patient can be taken into care involuntarily are already outlined under the Mental Health Act. It is needed, according to BC's chief scientific advisor, Daniel Vigo, for a minority of those with concurrent disorders who are unable to reach out for help and make the decision themselves. And he says their brains and our communities are paying the price. So a little bit of background about EB's position on this. He supported, this is not really new for him, he supported involuntary care during his 2022 election campaign, but then he basically backed off under pressure from activists. And he said at the time that he backed off that he believed that the move of expanding involuntary care would not survive a charter challenge. And indeed, right now, these provisions of the BC Mental Health Act is being challenged by a group called the Council of Canadians with Disabilities, who are arguing that the involuntary commitment provisions violate Section 7 and Section 15.1 of the Charter, so the right to life, liberty, and security of the person, and the right to equality. They say that the government's approach to forced treatment reinforces harmful stereotypes by equating having mental health problems with being incapable of participating in their own recovery. They also say that people who have been forcibly treated can be traumatized by the experience and subsequently avoid seeking mental health services again in the future, which ultimately they say undermines access to mental health care. So I'll just close by commenting on the situation in Ontario, where we live, but also because there's a leading Supreme Court of Canada precedent that gives an important indication about how this Canadian Council with Disabilities challenge, how this is likely to be taken up by the court. So in a case called Starson v. Swayze, which is from 2003, the issue of capacity to consent to medical treatment came up. And in a 6-3 decision, the Supreme Court ruled that he was a physicist, a brilliant physicist who had bipolar disorder and was frequently hospitalized. The Supreme Court ruled that he did have the capacity to refuse the proposed treatment and clarified that a test for capacity must look at whether a patient can understand the information relevant to the treatment decision and appreciate the reasonably foreseeable consequences of the decision. So if those aspects are met, that individual cannot involuntarily commit a person without violating Section 7. And in terms of Ontario's Consent and Capacity Board, so Ontario does not have provisions for involuntary commitment. It has a Consent and Capacity Board, which determines whether the patient has the capacity to consent to the medical treatment. It does not decide on what is the best interests of the patient. And I'll just, since Christine's away and we have a little more time, I'll just mention that I have some recent semi-personal experience with this procedure and how it ends up being implemented here in Ontario. I have a friend, a newish friend that I recently became aware of, and obviously I'm not going to give any identifying details, but I recently became aware that she was suffering from paranoid delusions. I met with her and she told me that she believed she had been implanted with a medical device in her sleep while she was tranquilized. I was super disturbed and I didn't know her family, but as soon as I left, I tracked down her parents, got in touch with their parents. Turns out her parents are absolutely lovely people who are obviously going through horrible time with their daughter who can't take care of herself. And the sort of hallmark of her disease, which the mother did tell me is paranoid schizophrenia, delusional paranoid schizophrenia, is that she's incapable of recognizing that she's unwell. That's like sort of the mechanism of it. So she can't support herself. She can't take care of herself. And so she will sometimes, wind up in hospital, but she has to be brought within a certain period of time before this Consent and Capacity Board. And at those hearings, the patient is assigned a legal aid or lawyer. And in the case of this friend, the legal aid or lawyer is frequently able to have the patient discharged on technicalities like late filed paperwork, things like that. And so this person is not getting the treatment that she very objectively, clearly needs and is preventing her from functioning in society. She's a healthy young woman who has high intelligence and really we know, her mother told me, when she is, taking her medication, she's able to get a job and have a normal life. So the whole thing is super tragic, super heartbreaking. We've already talked about the bigger philosophical issues around autonomy, and how, as libertarians, the whole matter of involuntary treatment makes us uncomfortable. So if you want to hear that discussion, you can go back to our April 24th discussion. But what do you think, Josh? This issue seems to be truly at a fever pitch in British Columbia, and honestly in cities across the country, especially in the last few years. What do you think? Do you think, when we talked about this yesterday, you suggested that maybe the courts would look at this differently if a left-wing politician like David Eby was the one that was saying we need involuntary treatment?
Yeah, I think that's a really important point. Yeah, like you've said, we are uncomfortable with the idea of individuals losing their autonomy or having medical decisions made for them. That can be pretty horrifying. There's this long history in the Western world where people were forced to undergo medication or like electroconvulsive therapy against their will, and we don't want to go back there. We don't want to have people who are competent or not posing a threat to other people be forced to undergo treatments that they don't want. But at the same time, we've seen the other side of this, and the other side of this is really horrific crimes happening in British Columbia in particular lately, but you see it here in Ontario too, by people who are experiencing paranoid delusions and who have been repeatedly causing harm to other people through the violence of their actions. And what's more humane in those cases, to put them in prison or to try and put them in a mental health facility where they can take treatment that is going to reduce the risk of that happening again and improve their lives. And I have personal experience with this too. Here in Ontario, like post Swayze, the system doesn't work. The system is really, really harming a lot of people. Primarily, it's harming the people who have mental health issues like schizophrenia. What happens, like in the personal experience I know, is someone who year after year after year after year is experiencing like psychosis that is causing harm to her and her family and to strangers. And every time she goes before the consent and capacity board, it's a crapshoot whether or not they're going to say she needs to be medicated. As soon as she is medicated, she's deemed to be capable of making decisions, because at that point her mind is clear, and the only issue left is her lack of insight into the fact that she is psychotic and has schizophrenia, right? So by the time she appeals, and there's like multiple levels of appeal, and like you mentioned, you get this legal aid lawyer who in her case tends to usually be quite good at what they do. She tends to win her appeals, right? So there's no permanent solution. It's just this roller coaster of constantly her family trying to get her care. And that's unacceptable. But the way the law stands right now is it's going to be really hard to overcome that Swayze decision, right? So, EB is probably correct that it wouldn't withstand a charter challenge. And so what's left at that point, if you want to do this, is the notwithstanding clause. So I think that's where this goes next, unless, like you say, like we were talking about yesterday, unless a court says, well, look, even David Eby, who's like the most sort of liberal person on this file in the entire country, like he's a former civil libertarian. He worked for the CCLA or the BCs. I think it was the CCLA in Vancouver, one of them. If even he says this is something that needs to happen now, maybe the court will see it differently and find a way to say this is constitutionally compliant. But I think the more likely scenario is it's going to require notwithstanding clause at some point. So it's unfortunate, but that's where we're at, and I guess we'll see what happens. Should we move on to bad legal takes? Do you want to give yours, Joanna, or do you have more to say?
No, let's move on to bad legal takes. So I'll go first, because mine is pretty short, and I'm going to cite from this week's BLT a frequent flyer on this section, Professor Heidi Matthews of Osgoode Hall Law School. And this is, of course, in the wake of the pretty stunning news yesterday that I think thousands of pagers that were carried by Hezbollah operatives in Lebanon were simultaneously detonated. The Mossad has not given any comment, but we can probably infer that they're the only people who could be behind something like this. In any event, and Ms. Matthews tweeted, if converting personal communications into IEDs isn't an act of terrorism, then I don't know what is. Well, this is a very telling tweet. So I looked this up. So there is not a settled consensus on the legal definition of terrorism, but there is a general consensus among international legal instruments. The Canadian definition of terrorism, the FBI definition of terrorism, that terrorism involves criminal violence intended to intimidate a population, which is targeted primarily at civilians. And so clearly, I mean, I don't think that you can get more targeted at terrorists than targeting the beepers, the pagers that are held on the body of Hezbollah terrorists, which this is not disputed. Hezbollah didn't dispute that these pagers were being used by its operatives. I suppose the only more targeted way you could get would be implanting some type of device like in your esophagus, which Israel probably also has the capacity to do, by the way, given that they are the leaders in medical imaging and invented the types of cameras that go down your intestines. So we'll just wait to see if they can get that much more targeted. But really, the more appropriate paradigm to look at the legality of this action is through the law of war. And that is because Hezbollah, first of all, claims to intend the destruction of Israel, but also more practically, it's been continually firing rockets since October 7th. Including most tragically this past July at Majd al-Shams, an attack that killed 12 Syrian children. Hezbollah also embeds itself in the civilian population. So the more appropriate paradigm to ask about the legality is proportionality under the law of war. And the principle of proportionality prohibits attacks that may be expected to cause loss of civilian life that would be excessive compared to the anticipated concrete direct military advantage. So here, of the thousands of beepers that went off, 12 deaths have been reported. 9 of those deaths have been claimed to be Hezbollah members. And besides that, so that's, of course, any civilian loss of life is tragic, but on any measure of proportionality, that is a low civilian to combatant death ratio. And then, of course, there are much broader military advantages to Israel if they carried out this attack, putting Hezbollah's communications on notice, being able to hack into Lebanese hospital records and identify who is admitted, who the operatives are. And I've seen footage of several of these pagers exploding. I'm sure many people listening saw the footage of a pager exploding in a grocery store where literally the person standing kitty corner to the tray of apples was utterly unharmed. So it's the most stunningly targeted widespread counterterrorism operation in history. And given that Heidi was broadly sympathetic to the October 7th attacks, she said they needed to be seen within the broader right to resistance. I'm so sorry, but your anti-Semitism is showing. Josh, what's your BLT?
So mine's a little bit more lighthearted, although I have to admit, watching all those beepers explode was somewhat enjoyable. My bad legal take goes to Cambridgeshire Council in the United Kingdom for disciplining an employee for her alleged discrimination against a colleague after she responded to his claim that his tutu-wearing dachshund was gender fluid. And I've read multiple reports about what happened here, and I can't find the exact words that are alleged to have been said, but here's my understanding of what happened. So this social worker named Elizabeth Pitt, who identifies as a lesbian, was in a Zoom call with her colleagues in Cambridgeshire when a coworker said that his gender fluid dog, who was apparently present at the meeting, identifies as gender fluid, and he wants to start a debate about gender, the human, not the dog. And Ms. Pitt apparently was happy to participate in this debate about gender, and she expressed views, which are extremely common, that she doesn't believe transgender women should be in single-sex spaces or in women's sports. And this led to a human rights complaint against Ms. Pitt, which resulted in her being disciplined by her employer for, quote, comments or actions in the workplace that might discriminate against others on the grounds of a protected characteristic. Thankfully, this bad legal take turns into a somewhat good legal take because just recently the Employment Tribunal actually sided with Ms. Pitt, saying that she was the one discriminated against, not the man with the gender fluid dachshund. And the employment judge has now ordered Cambridgeshire Council to pay her £63,000 for discrimination on the basis of philosophical belief, which I take it to mean something akin to conscience rights. And she'll get £30,000 for her lost earnings, $22,000 for injury to feelings, plus interest and costs. Unfortunately, this will be paid for by her employer, which is taxpayer funded, so that's not ideal. But most importantly, the council has been ordered to include freedom of belief and freedom of speech in their staff training going forward, so this stupid type of thing doesn't happen again. That's the show. As usual, we hope you'll rate us, review us, and subscribe, and you can support our work by visiting the Canadian Constitution Foundation's YouTube channel, by following us on Twitter, by visiting the CCF's website where you can sign up for our new and improved Freedom Update newsletter. The CCF is a nonpartisan legal charity funded by your donations, so please click that donate button on our website if you can. Thanks for listening.